Thank you very much for that kind introduction. Appreciate that. As the results of the referendum recede further into the rearview mirror, we've begun to gain a wider perspective on the extent of Brexit's potential impact. As Bill mentioned, Bojana and I are here today to talk to you about Brexit's impact on data protection. Perhaps to some that might sound like a rather esoteric topic. Our job in the next 30 minutes or so is to convince you of the topic's practical importance across industry and how its impact will be felt by every business represented here today. Given our complete immersion in the information age, it should come as no surprise that data represents significantly more than the zeros and ones of which it is comprised for business and governments today. Lots of people much smarter than me have come up with clever analogies regarding the role data plays in our collective lives. For me, the British data scientist Clive Hanby said it best when he quipped that data is the new oil. This vast, untapped reservoir represents limitless potential value. Yet, in its crude state, it poses real challenges for business. Companies have an excess of data, but a shortage of insight, he said. This next generation of insight needs to refine the crude data to achieve the ultimate goal, understanding customers. Like energy sources, data might as well be considered currency in today's information age. For evidence, look no further than the hundreds of cyber attacks plaguing international businesses on a near daily basis. In fact, hardly a week goes by without another report of a massive cyber attack into the systems of major businesses, impacting the personal data of millions of people. Why, you might ask, are cyber attackers repeatedly hacking into corporate networks in search of data? Despite numerous technical advances, cyber attackers hack corporate networks for the same simple reason that famed American bank robber Willie Sutton robbed banks in the early 20th century. You may recall Mr. Sutton's famous quote in response to a reporter's question asking him why he robbed banks. To which he replied, and I quote, "I rob banks because that's where the money is." Cyber attackers are no different. They are hacking corporate networks in search of data because in 2016, that, in fact, is where the money is. There is a robust market on the dark web where buyers and sellers of stolen personal data meet to transact business as if they were buying and selling fruit and vegetables in Covent Garden. As prominent cyber journalist Brian Krebs has pointed out, this market is so robust that the hackers innovate not only at the technical level to find new ways to exploit vulnerabilities, but have now begun to innovate at the business level to ensure that they can sell their wares. Mr. Krebs has noted that the purveyors of stolen data, akin to high street retailers today, are now building loyalty programs to garner repeat business from their customers, who in this case just happen to be criminals that purchase the data and then launder it to buy goods that they can sell for money. This is our reality in 2016. On the one hand, modern computing is opening up opportunities for businesses to tap into these vast reservoirs of data in pursuit of new insights that are driving substantial revenue. On the other hand, this 21st century refining process is premised on the very vast repositories of crude data that Mr. Hanby spoke of. And it is these repositories that represent a virtual treasure trove for criminals hell-bent on exploiting vulnerabilities to gain access to that information. This dichotomy is the definition of a double-edged sword, striking the balance between fostering innovation and protecting individual privacy is one of the great policy challenges of our time. Doing so with a resource like data that respects no borders, not dissimilar from the global environmental policy challenges of the last 5 decades posed by air and water, makes successful regulation on a global scale that much more elusive. Despite these policy challenges, the drumbeat of technological progress marches on. the primacy of data in our lives has led to the development of entire marketplaces for emerging technologies that facilitate both companies and governments' ability to derive maximum value from the data they maintain. Digitalization of business, data-driven innovation, and big data capabilities are driving substantial revenue growth, creating unprecedented opportunities to gain insight and improve operational efficiencies that benefit society in innumerable ways. In many cases, these new capabilities depend on the unimpeded 24/7 follow-the-sun movement of data around the globe. Today, it is entirely routine for a client to come to us who is a UK-based company that has retained a vendor located in Spain who stores data on servers in Latin America and provides cloud-based access to those Latin American servers to subcontractors located in India and the United States. This is our reality. We cannot turn back the clock. Such unimpeded movement of data is simply a critical component of sustaining long-term economic growth in the future. While this phenomenon has become increasingly clear to all of you, governments around the world simultaneously continue their efforts to build virtual walls around their borders in the form of cross-border data transfer restrictions. Largely in response to the cybersecurity concerns that I raised earlier, as well as Edward Snowden's 2013 revelations in the United States regarding law enforcement access to data, many governments have grown increasingly cynical about how the law regulates data protection when data is transferred beyond their own borders. In this respect, the European Union has been in the vanguard for the past 20 years, making it unlawful for EU-based companies to transfer personal data outside of Europe without jumping through a burdensome series of regulatory hoops. More recently, outside the European Union, we have seen a multitude of data localization laws crop up in a number of jurisdictions, including important jurisdictions to the global economy in Russia and China. As a practical matter, these virtual walls, in my humble opinion, represent a worrying trend as they create significant disruptions to the free flow of data necessary in today's business environment without any discernible benefits in the form of actual enhancements to the protection of personal information. That being said, within the EU, companies have been free to move data across member state borders, and as a result, UK businesses have benefited immensely from the UK's status as an EU member state. When combined with its special relationship with the United States, where the UK is generally considered the preferred entry point for American companies looking to enter the EU market, the UK has enjoyed a lofty status when it comes to locating data-driven businesses. In fact, earlier this year, Ernst & Young named the UK the leading center for fintech in the world, outpacing leading centers found in California, New York, Singapore, and Germany. There are a host of reasons that support this lofty status, including access to the single market in the European Union, substantial support provided by government to the technology and digital sectors, generally progressive policymakers, regulators, and regulatory regimes as a relative matter, and deep expertise in the financial and technology sectors from people like you. While these factors have contributed to the UK's prominence in fintech, while these factors are not, they're present in fintech in the UK, but they're not likely to disappear overnight. The prospect of Brexit certainly threatens to throw a spanner in the works for the UK's position as a global technology technology leader. I will now turn the podium over to Bojana to provide further insight into the European data protection landscape and how the UK's involvement in that landscape will be impacted by Brexit.
Aaron, thank you very much for painting this picture to us of sort of data-driven economy and society, and looking at Brexit against that picture is really very important. Something that Andrew has said this morning, he talked about financial services and kind of the four important movements that are the pillars of the EU, movements of services, people, goods, and capital. And of course, data is not per se one one of these movements, one of these four pillars, but data is going to accompany every single of these four pillars. Data is going to flow with people, with capital, with services, with goods, and frankly, data is going to flow by itself, and I think that's the picture you have painted very well. What I'd like to do now in the 20 minutes that we have, perhaps a little bit less, is just to paint a little bit more specific data protection context that is clouding further complexities of a Brexit. And I know data protection is a minuscule area for all of you and for many of us, and indeed for our Prime Minister and government as they're going to be negotiating Brexit. But nevertheless, I think it is an important one because, as I have said, data is everywhere. It is absolutely the center of your businesses, your digital strategies, and therefore we have to think about it. Now, in terms of data protection, we're sort of undergoing a bit of an upheaval, and those of us who work in this world, and I think you also as business leaders probably are aware that we are on the cusp of new European data protection regulations, so-called GDPR. Europe has passed now a new data protection law that builds on what we have currently in Europe, and frankly is probably leading in the world. And this law is going to become law of the UK as well. It will enter into force in May 2018. And so this law is going to have a really major impact on all businesses in terms of your digital transformation, your data strategy. They're going to be impacted by GDPR. Also, how you use, how you share and access data, how you organize your IT system, your services, how you work with your vendors. All of these areas will really be impacted by GDPR. And as you can see, the timing is pretty critical. May 2018, this will become the law of the land, so we have about 2 years to get ready. Now, I think somewhere in your packs you're going to see Hunton and Williams' Senior Management Guide to GDPR. Please have a look at that. We have a full guide for those of your teams who are actually working with this, and do send us an email and we'll send you that guide. So this isn't about GDPR, but I do want to highlight the need to have a privacy comprehensive program, the need to appoint data privacy officers, the impact this law is going to have on your ability to have big data analytics, the Internet of Things, the machine learning that you are deploying in your organizations, impact on your vendors, and of course, very hefty fines. And so, what is the relevance of GDPR to Brexit, or in the context of Brexit is what you're probably asking yourself. So first of all, given the timing, we are going to have that period of time where this new law is going to become the law of the UK land. Even if Britain was to leave, it's not going to leave by May 2018, which means we all are going to be subject to the new law. So we have to start working and preparing as though really it is going to happen, because it will happen. The second point to say is that GDPR is an interesting law in that it has got so-called extraterritorial applications. Even in 2 years' time, the law is going to apply to non-EU businesses who are targeting European customers, who are selling goods and services to European customers. It is going to apply to non-EU businesses who are monitoring behavior of Europeans. And this is pretty much scaring everybody in US and Silicon Valley, I can tell you that. And so with UK being outside the bloc, this GDPR may actually apply to us, even though it is not going to be the law of the land post-Brexit. And I think this really is very important implication as well. Now, of course, if we have a sort of what we call hard Brexit, with the UK is not part of the EU single market, then the laws will continue to apply, of course, if the EU wants to access the EU market. Now, the compromise may be struck. You heard Andrew talking about sort of light touch, Bill talk about soft Brexit, and that really may indeed be the reality. It remains to be seen. But at the moment, the Information Commissioner in the UK, as well as the government, expect that most businesses will be affected by GDPR one way or another, short term certainly, because it will become, as I say, law in May 2018, potentially afterwards as well, even though we actually exit the EU. Now, the third point of relevance of this piece of law is what Aaron has alluded to, in that the regulation, just like the law of today, regulates transfers of data across borders. And many of you may have encountered that in your work, where data about people that are accompanying your services and your products and the capital, that are restricted from being shared outside the EU, right? So transfers of personal data to countries outside the EU and EEA are restricted. They're subject to legal hurdles, impediments, and that will continue under the GDPR. And that is going to be the case. So today, a French company that wants to use a UK service provider is absolutely free to do so. There are no impediments, there are no particular legal barriers for them doing so, and that, of course, will continue under the GDPR. Of course, if the French company wants to use an Indian cloud provider or US cloud provider, the situation is very different. They have to go through a number of very costly legal mechanisms, hurdles, to ensure that the data can be stored on that cloud in the US or India. And that will be the case under the GDPR. So, of course, there are some mechanisms under which data can be transferred, and we will talk about that later. Some of you may have heard about the famous EU adequacy decision. The European Commission can actually find countries to be adequate, to have the level of data privacy law, data protection law that is essentially equivalent to that of Europe. Now, these decisions are very far and few in between. There have been just a handful plus of countries, Switzerland, Canada, Guernsey, by the way, out there as well, and Israel, so not extraordinarily helpful. US has never been declared adequate. And so that is one of the mechanisms, of course. Now, if the country is not deemed adequate, as per today's law and as per tomorrow under this new European data protection regulation, as I say, companies who are transferring data to companies, businesses outside the EU are going to have to go through these very costly legal mechanisms. And whilst it's wonderful for lawyers like us, it pays the bills, it is actually a real impediment for all the businesses. Of course, drives the costs, transactional costs, drives down the competitiveness potentially as well. And you could kind of see the picture I'm trying to paint of UK being outside the EU and having to go through these hurdles to ensure that we can still have access to the EU data market and to ensure that businesses outside the EU can actually share their data with us. And of course, this all against the backdrop that Aaron so beautifully painted, where data is absolutely going to be driving every business strategy of your company, our economic growth, frankly, governmental growth. Governments are using data to drive efficiencies in operations, in the way they operate, and benefits to all of us. So that's why really this is hugely, hugely important. And so I don't want to paint the bad picture, so I'm going to try to give you 4 options in which sort of these walls around the UK and this sort of somewhat isolationist position in terms of data flows can be avoided. And I have found 4 options. Andrew talked about 3 options in case of the financial services, but I do have 4 options just to confuse people further. And I think one important point to say is that we all here are speculating based on our area of expertise, based on what we care and like. We care about privacy, data protection, data flows. Andrew and his team, experts in financial services, and data protection is not going to be the main negotiating point. Absolutely not. Something else will be. But I hope that as the government does negotiate this whole point of data is going to be an important one, just like financial services for the UK is an important point for the City of London and frankly the whole of the UK. So, option 1. Option 1 actually corresponds to what Andrew has said, and that is we leave the EU, but we somehow have this arrangement across the EEA. And I appreciate politically this may not be very realistic, but in terms of data flows and data protection, this would enable UK, of course, to have unrestricted access to data in the EU. It would enable our European partners, companies, affiliates, customers, subsidiaries to transfer data to UK absolutely freely, but it does also mean that these rules that are created in the EU are created created without our input, without our ability to shape. And maybe just as an aside, in the space of data protection and data, UK has actually played a really important role. And you all have heard about digital single market and what Europe is trying to create, where really data is driving innovation and driving the growth of Europe and each of the countries. And in fact, UK with its very progressive views, UK with its phenomenal technological potential and ability and clarity of what is actually, what sort of rules are required to enable digital single market, to enable data flow. UK has been very influential. And I think to me, it's a great sadness that UK is not going to be able to exert that influence anymore. And I think what is going to come from Brussels to us, even if we are outside, we are going to be impacted by that, as I have shown, is going to be less pragmatic potentially, less business friendly. And I think it's a great shame, but just as an aside. So in this kind of EEA option that I say politically probably not very realistic, we will not have ability to influence anything. And in fact, yes, we would be subject to this new European GDPR and new developments in the way the law is going to evolve. And of course, some people have criticized the GDPR, and maybe you have as well, in your board meetings, looking at the cost, looking at the astronomical fines, looking at the administrative impact of actually regurgitating your compliance program, your data strategy, because of this new law. So in some ways, we get the benefits of data flows, but we also get the burden of GDPR compliance. And that is something that has to be really weighed. Now, option number 2 is not the EEA option, but UK adopts a lighter touch regulation similar to GDPR in essence, but not quite the same. And then we hope that our law would be found adequate from the European Commission's perspective and EU perspective. And this has got certain benefits. You could kind of immediately see those who have criticized GDPR will say this is greater, we'll have a little bit of a lighter touch, we don't need to have everything exactly the same way as EU wanted, and we can get the adequacy decision, but as I have said, these decisions take incredibly long time. It's going to take years to achieve one. I know there are countries like Japan, India who are interested but still not getting there. New Zealand has been refused for a number of years until they tweak something in their law. So I think that I just do not know personally how realistic this option would be, where we would be granted adequacy. Would that politically be the first thing that Commission is going to think about? And of course, you know, when we talk about the lighter touch, if our law is too much watered down, then it will not be essentially equivalent to the European standard, and then it can't be found to be adequate. So you know, that's the sort of catch-22 that we have. Now, I do understand and I do want to recognize that there has been a lot of discussion about Brexit giving opportunities to the UK in terms of data protection to create a regime which would be seriously light touch, which would actually drive innovation, which would enable companies to use big data analytics and for UK to become a real data hub. And I appreciate that that is it's a phenomenal, it would be phenomenal to achieve that. But as I say, we still have these issues around data flows and sharing of data and whether such a regime would ever be accepted or found adequate by the EU. Now, stay with me, option 3. Option 3 is very similar. We sort of, again, no EEA option. We adopt something which looks like a lighter touch, but we don't seek adequacy. We are hoping to get something which is called Privacy Shield. Now, has anybody heard about Privacy Shield? Yes, wow, wonderful. A couple of people are nodding, and that's something. So this is a very interesting arrangement that EU has negotiated with US after quite a long saga, which I will explain. And Privacy Shield, what it is, it's an arrangement where companies certify that they are going to comply with a certain level of privacy protection in respect of data that they take from EU to the US. And many US companies, big names, you will know them, Google has just yesterday confirmed that they are certifying with Privacy Shield, and so has Microsoft and many others. So many organizations are using Privacy Shield, a new Privacy Shield today. So we could kind of imagine the world where we have some kind of different data protection law, not GDPR style, lighter touch, and then we want to negotiate this type of Privacy Shield with the EU. But I do have to tell you what the history of Privacy Shield, and this history is really very colorful, at least for nerds like us who are interested in this data protection. The predecessor to Shield was called US Safe Harbor, and this arrangement existed for about 10 plus years, was negotiated a long time ago in order to facilitate these flows between Europe and US, really very important. And then, of course, following Snowden revelation, a privacy activist called Max Schrems. I want to tell you his name because I actually think we're going to keep hearing his name a lot, and he's going to become a serious corporate risk on everybody's radar. So please, Max Schrems should be in your enterprise risk management as a potential risk to everybody, frankly. So Max Schrems has actually started a campaign where he asserted that Facebook, and it doesn't matter, that was just Facebook, could be any company, is taking data to the US based on this safe harbor, the old arrangement, the old-style arrangement, in contravention of European laws. He claimed that there wasn't actually the equivalent protection. A safe harbor was old-style protection, and due to state and government surveillance, it was to be struck. And indeed, the European Court of Justice in Luxembourg did strike safe harbor. It found safe harbor invalid. And those of you who've been following Brexit discussions probably will remember very clearly from Michael Gove to some other QCs actually taking this judgment as an example of supremacy of European Court and how stupid this judgment was, and how could they actually strike data flows just by the letter, by the pen, or the stroke of a keyboard in that judgment. But the interesting thing was that yes, this agreement was found invalid, basically based on state surveillance and potential for state surveillance in the US, and therefore the new agreement took about a year and a half to renegotiate between the European Commission and the US, and that is the Privacy Shield of today. As I say, a number of companies are using them, but Max Schrems is not sitting on his laurels. I think he might challenge this new agreement still to say that it potentially is not relevant. And I will tell you a little anecdote to make you laugh. He did say after he heard of Brexit, he's a bit of a celebrity in data protection fields, as you can see. So he said in an interview in Germany, actually he's not interested in Privacy Shield. If UK does leave the EU, he's going to go after UK government for and GCHQ on the grounds of excessive state surveillance and therefore never being essential equivalence and level of privacy protection that we have in the UK. So there we are. He is a mischief, I think. Even though I know him, I can easily say that. And we are in a time of quite some legal uncertainty. Even this Privacy Shield that exists now, it may be challenged further in the courts. And therefore, this option that I explained, where we potentially hope for Privacy Shield, politically may not happen. EU may not want to negotiate anything like that with us. And legal uncertainty potentially is still great. Now, that leaves us with option 4, and that is we go our own way, we adopt whatever we want, and we are not adequate, we don't have Privacy Shield, and the data flows have to be subject to these additional mechanisms I talked about. So our partners, our customers, our suppliers will have to go through these additional hoops to share data with UK, and the same, we will have to do the same in order to have access to data in the EU. Now that, of course, makes the whole cost of transactions and doing business higher. It may hit bottom line because we will stop being competitive in some sense, and it isn't a great option, I think, for the UK businesses. Now, in conclusion, what do I conclude? These 4 options are just me and Aaron crystal gazing in a crystal ball and trying to say, well, this is how it could go. I know this is an important part for our government. I know our DCMS is actually thinking about this, consulting. We've been speaking to them as well. And so in this kind of era of uncertainty, I really want to kind of impress with you that we're probably going to be in some place place where some virtual walls around UK will exist, and we'll probably have to do something to enable these walls to crumble, to enable our business to be competitive and have access to this new technological revolution. But among all the uncertainty, I think one thing is certain, that today, all of you and all of us will have to get ready to comply with this new EU data protection regulation. And that law will be law of the UK as we are negotiating Brexit, and it may impact and may be relevant for us longer than perhaps we even expect. I'm happy to take questions on sort of what this would mean, and whether actually this law would whether we have any options in lowering, and maybe we can talk about that at the panel. But there are lots of things here in this law that actually I cannot see the government kind of giving away. Security breach notification, for example, that's like good. That is not something government is going to give away, right? Even though it's a European style or European imposed. So what I would like to leave with you is sort of looking potentially at a sort of positive side, and saying that while there is this legal uncertainty, while we're looking and waiting for clarity, and Theresa May said there's not going to be commentary on Brexit, but we'll get some, right? I'm sure. Let's get ready for GDPR, and let's get ready to kind of embrace some of the opportunities that this new law is presenting to us. I actually think that we and you as business leaders should be considering data protection and privacy as a competitive advantage, as a business enabler. Organizations that actually proactively manage their data, how they use it, how they can reap the benefits from big data, Internet of Things, analytics, how they protect and secure, I think are actually going to do better than the others. Data privacy is absolutely essential in an element of digital confidence and digital trust. And no matter in what business you are, consumer business or business to business type of company, that is going to be critical for you. And so accountability and responsibility around uses of data, and dare I say, even corporate digital responsibility, making data privacy part of your corporate digital responsibility is going to be the smart way forward for smart organizations, particularly in this data-driven economy. And those organizations who kind of get this right are really going to be leaders, and they're going to reap benefits of data much more than their peers.